Good evening, everybody. Thank you for coming. I'm Ben Powell, the director of the Free Market Institute here at Texas Tech University. And this is our keynote lecture of our fall lecture series. And I look forward to introducing our speaker, Professor Richard Epstein, in just a minute. But before I do, I want to tell you about what's coming up in our speaker series this semester. Next up will be on October 28th, Alex Nowrasteh, speaking on mass deportations, visas, and due process immigration policy in Trump's America. Then finally, to conclude the semester, we'll have Mark Pennington from King's College London, speaking about freedom and postmodernism in the market economy. Before I introduce our speaker, in light of the tragic event of last week and the conversations about free speech that this has started on college campuses around the country, I think I'll take just a moment to say that for 13 years now, almost 13 years, we've been doing these here at the Free Market Institute. And we've brought in a variety of controversial speakers, people who will push the ideas of people on the political left, of people on the political right. There's probably been something to make everybody feel uncomfortable with over the years, and Texas Tech has always done free speech right. We've had our events, people politely listen to the speaker. At the end we have Q&A and people ask questions, sometimes hostile questions, and that's perfectly appropriate in how free speech should be done. And news is driven by outliers, and when we hear these horror stories about free speech on campus in the news, they are often not outliers. And I fully expect that at Texas Tech University and the Free Market Institute in particular, we'll continue to go on as normal and have great free speech events with our public lecture series. And I thank you all for participating in that. So, with that said, allow me to introduce our speaker. Richard Epstein is the Lawrence Tisch Professor of Law at NYU School of Law. He served as the Peter and Kristen Bedford Senior Fellow at Hoover Institution since 2000 until recently when he switched his affiliation to the Civitas Institute, which is at another school here in Texas that will remain nameless while I'm doing the introduction. Before that, he was also, or he still is, I guess, the James Parker Hall Distinguished Service Professor of Law Emeritus and Senior Lecturer at the University of Chicago, where he spent much of his career from the early 1970s into the 2000s. He's been a member of the American Academy of Arts and Sciences since 1985. He's a member of the Mont Pelerin Society. He served as the editor of the Journal of Legal Studies from 1981 to 1991, and then the Journal of Law and Economics from 1991 to 2001. From 2001 to 2010, he was the director of the John Olin Program in Law and Economics at the University of Chicago. He's the author of more than a dozen books and more than 100 law review and academic research articles. This past summer, Professor Epstein co-authored an amicus brief that was filed with the U.S. Court of International Trade, challenging the legality of President Trump's reciprocal tariffs. He's here today to tell us why he believes these tariffs are wrong on the law, wrong in facts, and wrong in economic theory. Please join me in welcoming Professor Richard Epstein.
Speech is making my way safely up the stairs.
I'm not sure if the mic is turned on.
Oh, it's not turned on, but it's in one of the pockets. And if I don't get it, I'm sure there's technical help here, which can do this. All right, it is now on. Thank you all very much for coming. I do appreciate it. This is a very difficult to talk about, Trump. In dealing with him generally, I've always adopted the following phrase. It's called Trump a la carte. And what the phrase means is you know what you think about Trump on one issue, you have no idea what you're going to think about the man on the next issue. That everything has to be taken one at a time in a way to figure out what's going on. So I'm not going to talk about any of the good things that the president has done, but I'm going to talk about perhaps the worst thing that the president has done, which is to try to use the legal system in order to impose the most comprehensive set of tariffs on more nations in more ways and more places than anybody else has ever done anywhere at any time. And it's a very bold kind of question. And so the first question that everybody wants to ask is exactly, does he or does he not have authorization to do this? And I've agreed to talk about this against my better judgment because there was a recent decision that was issued by the Federal Circuit overseeing the Court of International Trade, which said two things. One is that he has exceeded his powers under the particular statute, and two, they were not going to do in the short run anything about it, which is the kind of situation which is extremely uneasy. So what we'll do is we'll set out the basic scheme for that, and then what we'll do is we'll switch the lens and talk about the issues that might well have been talked about in this case, but which they systematically refuse in any coherent fashion to address, namely how it is that you're supposed to deal with emergency situations and what's the strength or weaknesses of reciprocal tariffs vis-a-vis everything else. And then in order to answer those questions in the most general form, what you have to do is to relate it to the theory of tariffs that has been developed since Adam Smith, essentially saying that the way in which you succeed in any large institution of trade is to create a large free trade zone so that goods move as smoothly and as easily across national or state boundary lines as they do within any given jurisdiction. And so the point about this stuff, quite simply, is exchange, generally in voluntary markets by sophisticated parties, yields gains to both parties, and to the extent that you interfere with that, you're always going to make things worse, even if you're clever enough to think of phony rationales, which say that you're going to make it better. And so to begin with the basic type of situation, there are today regulating tariffs a huge number of statutes, all which have titles and content that are largely incomprehensible. One of the statutes in question is affectionately called IEPA, and after due diligence, I memorized what the title is. It's the International Emergency Economic Powers Act, which was passed in about 1974, replacing FWEA, or the Trading with the Enemy Act. And these are statutes that decide to give the president some ability to deal with situations in international trade where there is some kind of an emergency that requires his immediate action. And so what happens with respect to the Trump situation is you might think that you would have to explain why it is that you're imposing worldwide tariffs as an emergency, but that's not a question that this particular court seeks to answer. Instead, what it does is it looks at the words in IEPA and it asks the question as to whether or not you can isolate the words talking about the regulation and imposition of regulation on given goods. And the question is whether or not regulation on these goods is sufficiently broad to include the word tariff in the overall definition of the subject. This is a question that lawyers love and which ordinary people blanch whenever they see it. And when you're trying to figure out how you answer that question, do you take these words out of sequence or do you not? And so what we do is we get 128 pages of learned opinions which reach the following conclusion, that generally speaking, the power to regulate tariffs is something which is delegated exclusively to Congress, that Congress has actively exercised that power directly by imposing tariff schedules on huge numbers of goods for every sector of the economy, and indirectly by explicitly delegating to particular agencies the power to accept or to adjust tariffs within very carefully defined parameters that are going on. IEPA is the only statute that gives the president unilateral authority to act without any of these side constraints. So as a matter of his political judgment, he tries very, very hard to say that I can work within this statute. And one of the arguments that the court made on the other side is when we read a statute, we read it in context with other statutes. And if these other statutes impose real restraints on you, you have to show us a very clear reason as to why it is that we are not going to respect those jurisdictions and to put it in this one. They then continue with the notion that since these powers are explicit and you wish to make a major change in what's going on, what you have to do is to meet something which is now affectionately called the major questions doctrine, which in constitutional lingo means that if there is a large question that is decided by the president or by an administrative agency in the exercise of its delegated authorities, you have to show very convincing authorization that there's something in the text of the Constitution or of the particular legislation by Congress that does this. And so what the court then does is it looks around and it concludes that this is far broader than anything that has ever been done. This is clearly a major question. We don't decide whether it's definitively or not definitively covered in the particular case, but what we do decide is you flunk that particular doctrine. There's not sufficient clarity, so we don't do it. What they then did was to say, what's the remedy? And the general view is, if there is a serious violation of the statute, there are a series of tests based upon a case called Winters from 2008, which determine whether or not you issue a preliminary injunction, where the single most important factor is whether or not you think there's a substantial likelihood that the person who's trying to get the injunction will win on the merits. I thought that was pretty clear that there was that likelihood, but what happened is the court now switches around and it says, we're not going to do anything. We hope that the Supreme Court will take this case on an expedited basis, and the importance of that is it means that the Trump maneuvers in the interim will continue to take place at whatever speed and rate that he wants them to do, because there's no judicial authority which will overturn them, which raises then the very unhappy specter that you put all these things into place, and then you say you don't have the power after all. What do you try to do to unravel the knot that has been put into place by all the action that has started to take place? But in law, for every doctrine, there's an equal and opposite doctrine, which tells you the opposite thing, right? And so in this particular question, there is another doctrine out there which says that when you're dealing with executive power, the power of the president has its maximum, and his judgment has to be respected. At which point there are then two variations of this doctrine. The first one says, whatever Lola wants, Lola gets, meaning that if the president decides that there's an emergency, he can decide that and then decide the remedy. And there's another version which says no, what he has to do is to show some kind of a weak justification for doing this. And the people who believe that says, if you look at this statute, you read it, torture it, or whatever, in ways that give the president that particular power. And so that what you do is you now have a dissent which says that he was within his powers. The case will go up to the Supreme Court. They will argue it. My betting, and it's only betting, is that the first presumption, major questions will prevail over the second one, dealing with the situation on executive power. So that's the way in which this conversation starts. And then the question that you want to ask, why are they talking about this when everybody else on the face of the universe is talking about this in very different terms? And so the first thing to mention is the word emergency is put into this particular statutory title. And the question is, what on earth do we mean by an emergency? Well, as ever, if you see a word like this taken in isolation, the best way in which to understand it is to see the way in which that particular term has been used in other contexts involving other types of situation. And the term emergency, or its equivalent, roughly speaking, necessity, has been an active term in the lingo language since Roman law, one of my specialties, moving up forward. And this is what the term means in all these consequences. By way of a simple example, you were at sea in a boat, a huge storm comes up, and the only way in which you can make it safe is to dock your boat on somebody else's land. Does the emergency justify the invasion of somebody else's exclusive right of property? And the answer that is always given to that question is yes, so long as the emergency exists. The definition of emergency that's used in these cases, starting in Roman times, working up to the very present day, is there has to be an imminent threat to the life and safety of various kinds of individuals for you to do it. So if you say, I have an emergency because I need to get to an appointment, and if I don't dock at your dock, I'm going to be late because I have to go 2 miles further down before I can get the safe passage, that may be a personal difficulty, but doesn't count as a kind of legal emergency. Now, why is it that the law is so stickler about this? Because essentially what the doctrine of emergency or necessity says is we suspend the ordinary property rights that govern interactions between everybody else, including the standard norm that I have a right to either admit or exclude you from my property, depending upon whether I want to have a personal relationship with you or not. And that's the basis of 99.9% of the transactions that we have. I will ask anybody in this room who has had an emergency in their lifetime, which has required them to put their boat on somebody else's dock, to raise their hand and then to meet me outside and we talk about it. But generally speaking, this is the kind of thing which happens only under extremely rare circumstances. And with respect to emergencies at the sea, the doctrine never really applies because there's a well-known custom whereby people always help other people who are in distress, wholly apart from the legal conventions about this. And these customary rules are extremely powerful and of very high influence. So then you start to say, well, Professor Epstein, this doctrine doesn't really apply to anything having to do with financial issues. And the answer is, you are right, it doesn't. But one of the capacities of the common law is to figure out how it is you put together intelligent analogies to other areas. And so if you start looking at the kinds of cases that trigger the financial situation and government interaction under IE, they all fall into the following pattern. There is a normal pattern of distribution of some kind of currency or some kind of goods between different nations. There is then a huge flare-up. There's a war that starts to intervene, and nobody can quite honor the contracts that they've made by way of delivery because of everything that's coming. At this particular point, what you have to do is to suspend trading and then try to figure out exactly how you pick up the pieces. And the rule with respect to this, when they're bona fide financial dislocation and emergencies, is your just solution will leave everybody unhappy. There's a huge loss there, and your job is to figure out how you allocate it fairly between two parties. And so the system has always worked on that. The one case in which there were tariffs was one in which it turns out that the Iranians seized everything, and that surely qualified as a financial emergency. They then put together a board which was allowed to adjudicate those cases, and they put some tariffs in the mix, but not large numbers. So in this particular case, what you now do is you go back to the opinions that were written and ask the very simple question, what was the emergency that they defined with respect to IE? And the answer is they don't talk about it. In fact, if you go back to the Trump situations, there are two kinds of cases that he pointed. Both of them, I think, are very dangerous. One I will mention, and the other I will discuss in greater difficulty. The first are the various kinds of trafficking offenses in which you're sending fentanyl all over the border from Mexico or from Canada into the United States. And we think this is a kind of an emergency that allows us to do, well, what, to seize the goods, or to arrest everybody involved, or to declare war on the nation that's sending it. The president has actually taken that last position under the Alien Enemies Act. And I think virtually everybody thinks that smuggling goods into the United States is not the same thing as the emergency created by a wholesale invasion. And so what you do is you have a basic pattern in which what he has done is he has denatured the term emergency so as to make it so broad that anything that happens is an emergency, which means that you could turn the traditional regimes of property upside down at the statement of the president. So how is this thing treated under all of the statutes that do deal with emergencies? And what they do is they take a very different form from the one that the president said. And the first point is they divide the analysis into two parts. The first part asks yourself, is there, objectively speaking, an emergency? And then the second part asks, what's the president supposed to do about this? And whether you talk about international agreements on trade and tariffs, or this particular case, or the WTO, the World Trade Organization, the answer has always been the same. You cannot let an executive whose power depends upon the declaration of an emergency to have complete discretion to decide that the emergency exists. There has to be some independent way that you can determine that. And you know the kinds of definitions about suddenness, extremes, and so forth. And if the president has a credible case that his situation falls within that, you may defer. But if you don't find that there's an emergency, he has no discretion to manufacture one and to impose whatever remedy he wants. So we now look at the tariff side of this and to see what the President of the United States declared as an emergency. And what he said is the emergency that exists is worldwide. It began somewhere around 1930, and it consists of the fact that the United States, on reciprocal arrangements, that is, me to you and you to me, but no third party involved, we have traditionally run trade deficits with other countries. And the emergency is that we cannot allow those deficits to proliferate. And so therefore, I can intervene in requiring by reciprocal bilateral arrangements between the two of them. And until somebody else agrees to them, my remedy is to stick them with tariffs that start from 10% on everybody up to, say, 50% with respect to what we want to impose today on India. China gets special yo-yo treatment. It goes high, it goes low, it goes left, it goes right, and nobody quite knows where to stand because what the president said is we can work these negotiations out. And in a bit of idle optimism, he sort of announced in April, I expect to have 60 or 70 of these agreements in place on a reciprocal basis, and the number of agreements he has in place is 1. Now the question is, what's going on with his particular analysis? And there are 2 parts to the mistake. The first thing is, what is his definition of emergency? And then the second is, why these reciprocal agreements are the appropriate way in which to respond to them. And his definition of an emergency is a chronic deficit in any 2-party relationship. Why is a deficit bad? Well, he doesn't explain that to you. So let me see if I can try to explain to you why it is that he is basically chasing a red herring, and that even though chronic deficits of a system-wide nations, not only with one country, but across everything, may, probably don't, but may give rise to some situation. Just take a very simple kind of situation between 2 individuals, and then later on just extend it to say, treat them as though they were 2 nations. So it turns out that I'm somebody, and what I do is I manufacture cars. And what I do, in effect, is I buy my tires from somebody else. And what I do is I pay him for all the tires that I get. And it turns out there is now a chronic deficit between me and him, because having bought millions of tires from this one company, it's very unlikely that they would want to buy hundreds of thousands of cars from us. And so what happens is there's a chronic deficit between the 2 countries. And the question is, should we be worried about it? Well, there are 2 following things to worry about. One is the question, what does the volume of trade tell us about the general welfare involved in this case? And it's sort of one of the basic theorems of international trade. I like to call it the 11th commandment. What it says is there are mutual gains from trade between 2 voluntary partners. So if you hit somebody over the head with a brick, that doesn't quite count. But in international trade organizations with highly fluid parties, no coercion of any sort, the word voluntary transaction sticks as an accurate description. And so once this happens, if each of these transactions produces gains for both parties, it means that the seller of the good gets lots of money from it, and the buyer of the goods gets lots of money from it as well. And so what happens is the higher the volume of trade, the greater level of prosperity between 2 countries. And generally speaking, greater prosperity between 2 countries does not count under anybody's definition as a crisis. But at the same time, if you just look at those 2 countries, all the trade goes in one direction, just as it did with respect to the person who buys the tires and then sells the car. And at this particular point, the deficits just become enormous. And so what Mr. Trump says, that's the crisis. Well, what does he propose to deal with it? He wants to have reciprocal arrangement. Well, this is like trying to do barter instead of sale. What it is that I have that I can sell to this country, we sold me all the tires, it's not going to be cars. So now we're going to force them to buy things that American companies don't want to sell them and that they don't want to buy. And so the reason why all of these agreements have basically blown up is that unless the 2 countries have natural trade moving in opposite directions of goods and sales, there's no way that you can overcome that particular sort of deficit by making them buy something that they don't want to have from us and that we don't want to sell to them. And so all of these cases essentially end up as crisis cases, at which point the notion that you're putting in the tariffs in place in order to lead to bilateral agreements that will then lower tariffs around the world is a total illusion. And so what is the way in which we get rid of the particular fallacy? There is today one of these imperfect international organizations called the World Trade Association, which is the successor of another world organization called GATT, the General Agreement on Tariff and Trade. And GATT was extremely important because it was an effort after the Second World War to try to introduce a general regime of free trade by adopting a series of strategies which says if you reduce your tariffs to one trading partner, you cannot give it most favored nation treatment over everybody else. And the GATT and the WTO basically always worked on a multilateral basis, and they try to get large numbers of bases to lower their tariffs, and some success. They always allowed bilateral agreements, but that was not the general kind of case. So why is it that the reciprocal tariffs fail when this other stuff turns out to succeed? Well, what you have to do is to now go the next step, right? And so we had this manufacturer buying tariffs who runs huge deficits, and now he sells automobiles that contain not only tariffs, but 4,550 different components from different places. And what happened? He sells these things, and he now gets lots of money from the cars that he sells. So he's running huge benefits with the balance of trade. And the question, does that mean there's an imbalance with him taking advantage of everybody else? No. What it means is those are also mutual gains. And then if you put the two transactions together, you realize that he gets a huge cash loss from the first one, a huge cash gain from the second one. The deficits, when you look over a larger system, tend to cancel out. End of the crisis that's happened. And then the issue is, well, what should we do about this? Nothing is a very fine first approximation. If you keep the tariff barriers low, what you do is you increase the volume of trade across the boundary lines. The deficits will fluctuate one way or another, but the general gains from trade will succeed. So you start looking at the United States. What happens is we have a president who kind of uses the informed language of the street, that is vulgar. So everybody in America is getting ripped off. And then you start looking around. America has a relatively low trade sort of situation compared to everybody else. And what happens is, of course, we have made bloody fortunes for this. And the European countries, which have high tariff barriers, have stammered, stuttered, and essentially find themselves in a case of genuine decline, leading to major economic dislocations that are playing themselves out right now as we speak in Germany and in France, big time. And these are high tariff nations. So why is it that we with the low tariffs do better than these creeps with the high tariffs? And it's important that you understand what's going on. What happens is you have high tariff. It means that anytime you want to buy a good from somebody else, what you're going to have to do as a local company is to pay a huge amount of money to get them in. Now this is going to influence adversely consumption, like the coffee coming into the United States from Brazil. But more importantly, for international markets, if you are a European manufacturer and you want to manufacture cars and you have to import the tires or anything else, you're paying more for the input. So that when you turn around and try to sell it into the export market, it turns out you have to charge higher prices to offset the tariffs you paid in order to acquire the inputs. And this turns out to be generally highly suicidal. So if the United States says, okay, you do this, somebody's going to pay the tariff on that. We may have to pay some of it. But at the same time, we're also making automobiles, and we don't have that encumbrance because our inputs are not subject to tariff. So when you start selling to third parties, the European guys who have high tariffs to protect themselves essentially have strangled themselves when it comes to competition for third countries. And if you look at this, there maybe European countries are 10 and the United States is 1. There are 100 other places in the world where you're trying to sell cars. And it turns out that the Europeans have systematically crippled themselves for this activity and for many others. So just to give you one statistic about the thriving economy behind Paris, the fair market value of Apple stock in the United States is worth the entire value of all of the stock companies in Germany, which is a major trading bloc. Well, how does this thing start to happen? Well, the only thing that can happen is through some kind of a free trade arrangement that allows this situation to mature in a perfectly sensible fashion. And so that what takes place is that the argument that you're doing this by way of self-defense means as follows. Whenever you put a tariff on an import, you're not just taxing the person who's selling you a good, you're putting a tax on the buyer. The buyer turns out to be your citizen, your company. And what you've done with this particular buyer is you've crippled him so that he cannot compete with anybody else in third markets. It's not that the United States is unambiguously better when it sells to this guy, but the system is unambiguously worse when it turns out that the tariffs put on by some people, in fact, are going to damage everybody else. So when you then start to look at this and ask yourself the question of whether or not when you're dealing with tariffs, these things create an emergency, this is the following answer. He says that tariff deficits are an emergency which has existed since 1935 or so. And it turns out that's sheer fantasy. This is not any form of an emergency. In fact, it doesn't have anything to do at all. The last piece that one has to put together in this puzzle is even after you map out all the cases where my buying cancels out my losses of selling and so forth, there's still going to be some net residual that will take place. And one of the things that happens is that net residual all that ends up in the United States, which has therefore a smaller chronic deficit relative to GDP. But this is hardly a tragedy. If somebody is willing to leave their money into the United States, they're not going to put it in a bag and let it rot. They're going to start to invest in American firms and hope to get the return on that. And so that what you now have is yet another positive sum transaction. So the order to make this thing work, what you have to do in the worst possible way is to try to figure out what it is that's going on in this particular situation that creates the net deficit that requires the intervention in question. And nobody can do it. And I've also explained to you that barter is a very inefficient transaction, and that's what's going on with reciprocal trade. So for those of you not familiar with the sort of economic theory of barter, I'll just mention it very briefly to you. It turns out that I have a commodity that you want, and you have a commodity that I want. So you have a horse, and I have a cow. And what we would like to do is, I value the horse more than the cow, you value the cow more than the horse, is to work in exchange. The problem is the cow and the horse are not equal in value. And so if you make a trade with the unequal, you're going to have to throw something in. And that something is going to be called boot, something that you add to boot to the transaction. But what is it going to be? Because remember, you don't have money in this economy. So you're throwing a chicken or something like that. But the chicken overvalues it, so the guy goes back to you and he starts to give you a baseball club. And these transactions slowly work together. And the moment you realize this, you realize that the matching is not very easy. It works a little better with a commodity like oil, which is essentially a fungible good, infinitely divisible, than it does with animals, which are not individually divisible. Nobody wants to buy 8/10 of a cow and leave the other on the cutting room floor. And so what happens is, if you go back to Roman law, the first passage on the law of sale says that sale arose out of barter. And what happened is you introduce this medium of exchange. So I can buy something from you with cash. When you have the cash, you can buy something from somebody else. And the same thing with respect to the other goods. So that what happens is, using cash means that you no longer have to match goods with goods. And the gains that you have from having separate valuations and separate transactions overshadowed by hundreds of times the additional cost that it takes to print and to run a currency, which is not a trivial problem, because you have to worry about confiscation, counterfeiting, and all the other stuff. And you do that because you know if you try to go back to barter, the entire problem is going to go back. Well, that's the kind of regime that Trump wants to go to. And he simply does not understand how it is that this system is working. So let's go back and say, what do you do to understand this in terms of general theory about trade across boundaries? And I think the easiest way to do that is to start with the United States. And what happens is, the United States at its formation had 16 states. Now we're up to about 50. And the question is, how do we introduce a free trade zone across all of these states? So that if you're making goods and manufacture in Massachusetts, you can sell to somebody in New Hampshire and buy some goods that you need from somebody in Illinois, and repeat that thousands upon thousands of times. This is not an easy thing to do, because if you recall, the United States formed roughly in 1776, and that was the year, of course, in which Adam Smith wrote The Wealth of Nations. And The Wealth of Nations was essentially a sustained treatise against the dangers of mercantilism, i.e. trying to figure out special protections that you give for your own domestic manufacturers by putting up foreign tariffs to keep everybody else's goods going. And he said essentially it's the road to death, discrimination, and worse. And you know what happened is the founders of the American Constitution read all that stuff, and they largely believed it. And then they had to face the very difficult problem. When you put together a union, you put together a union of sovereign states at the time, and one of the attributes of sovereignty that a state has, every bit as much as an individual to land, is the right to exclude other kinds of individuals. And so you now say, well, maybe what we ought to do is to try to handle this by bilateral negotiations. And if you do that, you will see replicated within the United States exactly the same kind of problem that you see in Trump's world
it turns out there are too many deals that have to be made on a bilateral nation. So one nation has to make a deal with 13 others, and then the second nation has 12 other deals. You have to sum up a huge number of bilateral deals, and it doesn't. So the way in which they thought that this would be done was to try to have centralized power in Congress so as to allow it to reduce the barriers that otherwise exist amongst the different states. And the provision that they passed, which was designed to do this, was called the Commerce Clause. And what this said was Congress shall have the power to regulate state commerce with foreign nations among the several states and with the Indian tribes. 3 kinds of variations on that. And the theory was if Congress had that particular power, what it could do is impose restrictions on the state so as to prevent them from enforcing the tariff barriers that exist. Well, it turns out when they put this together, they did not realize that Congress was a very complicated political kind of body, and that there would be state delegations that would resist to this, that, or the other kind of restriction. And it turns out, if you then follow the history of American constitutional law, the number of nationwide edicts from the Congress, which got rid of these state barriers, was exactly 0. Defendants made a very fatal miscalculation because they did not take into account what is now called the public choice dimension of stuff, which is when you're making political decisions with self-interested actors, they don't automatically glom onto the ideal solution of free competition in any market, whether it be on tariffs, antitrust, or any other board. So what happened is the courts ride to the rescue. And the general view is if you're riding to the rescue as a judicial system, there has to be some cheating. The way in which the American Constitution has worked is fatal questions in the original design have often been cured by unprincipled decisions that have gotten matters right. And you then have the problem of legitimacy both ways. If you go back to the original, you doom the nation. If you keep with the other stuff, constitutional purists will say you can't do that. And that battle continues to be fought to this very day on these grounds. But in the case called Gibbons and Martin, what happened is Chief Justice Marshall issued an opinion which said that if you wish to run a ferry from Elizabethtown, New Jersey, into New York City, you did not have to pay a license fee to the successor of Robert Fulton, who had a patent on the steamship, which you were trying to use, because you were allowed essentially to go freely across state lines in interstate commerce. And he wanted that particular power because he understood the blockade that otherwise took. Now, that in effect may work in some particular kinds of cases because he found that there was a statute called the Licensing Act that allowed the United States to license boats to go up and down the Atlantic coast. And he read from that statute that it could ignore the state laws on tariffs and so forth and blockades, very dubious construction. And then there was something else. He said, I've got a better idea. I don't care whether there's a statute like the Licensing Act at all. The Commerce Clause is dormant, meaning in effect that if Congress passes nothing, the free trade ideal is so powerful that the courts will inform any kind of restrictions against illicit restrictions against trade inside the United States. And that became the dominant position. So that you then have, by the time you get to the 1950s and so forth, 2 completely odd documents. The first is the federal government in the exercise of its Congress power can create all sorts of cartels, which is an utter disaster, but that's what they said. And then the same Commerce Clause in its dormant side that the states could not create any blockades, but as against them, it turns out that we have to have free and full competition. So what's going on in effect in all of these particular cases is that no matter where you go, no matter where you start, no matter what it is that you want to do, there's always some bad actor out there that wants to sabotage you. And then the question is what you do to get around it. And I'll end on this note. When it came to the post-war period, the United States was generally internationalist orientation and strongly backed the kind of free trade regime which I'm talking about. They didn't do it perfectly, but they certainly did it. And the point was extremely important because generally to make a multilateral arrangement work, there has to be some dominant power who is prepared to stand behind it and give it shape and substance. And the United States, at the end of the Second World War, was an unrivaled power because it was the only major democracy standing without serious military damage to itself, most powerful army in the world, and everything else, and we were able to make it stand with this international strength. What's happening now is there's a kind of withdrawal from that sort of approach, and the idea is we're going to do this thing under American first policy, and the tragedy is when you decide that you are going to put America first on these kinds of situations, and then you understand all the implications that follow out from the fake declarations of emergencies, what you've done really is to put America last. And so we now face the great challenge that the Trump tariffs, which are aimed at everybody else, will hit us first. And this is not a good thing for this country, not a good thing for our political economy, not a good thing for our political alliances with other nations. But he seems to have this theory. And what does it show? The world would be a better place if he had taken a freshman class from my good friend. Thank you. Done.